GDPR requires certain organizations to have data protection officers. The requirement applies if you are a public authority or a body, your core activities require large-scale, regular, and systematic monitoring of individuals, for example, tracking online behavior. Or third, your core activities consist of large-scale processing of special categories of data or data related to criminal convictions and offenses. So, for example, a hospital who's processing large-scale quantities of healthcare data would require a data protection officer. From a professional perspective, most organizations are going to require a data protection officer. GDPR specifies the qualifications of a data protection officer in a limited capacity. The law says that data protection officers should have the required expertise and experience with data protection laws, and guidance indicates that data protection officers should have experience and expertise that corresponds with the processing activities of their organizations. A couple of examples. If an organization performs complex artificial intelligence review of advanced cybersecurity threats, then their data protection officer should have familiarity with both artificial intelligence and cybersecurity threats and the corresponding laws. If an organization is a payment processor, then the data protection officer should have experience with both financial transactions and the corresponding financial laws that govern those financial transactions. GDPR specifies 5 tasks for a data protection officer to perform. First, data protection officer must inform and advise its organization on, including employees, on the company's GDPR obligations. Second, data protection officers must monitor and review compliance with GDPR and other data protection laws. And that includes reviewing an organization's internal policies and procedures, as well as raising awareness of data protection issues, training staff, and conducting internal audits. Third, data protection officers should advise and monitor data protection impact assessments. Fourth, data protection officers are a primary point of contact for supervisory authorities. And as such, their 5th requirement is to cooperate with supervisory authorities in the course of an investigation or an inquiry. A data protection officer must have the requisite independence to perform their tasks. They cannot be unduly influenced by senior management to come out with a specific outcome regarding advice or a compliance review or input into a data protection impact assessment. A data protection officer can be both an internal candidate or a contracted party. Either way, a data protection officer must be accessible both to internal employees and to data subjects. One of the ways that an organization can make their data protection officer available is to publish their contact information on a corporate webpage, for example, and also to notify a supervisory authority about the identity of their data protection officer. Data protection officers must also have the requisite resources to perform their tasks. That means they have to have enough time to do any other job that they do, along with enough time to perform their responsibilities as data protection officer. They may require financial resources. They may require software and hardware resources. They may require staff to help them perform their task. The data protection officer responsibilities can't be delegated among multiple individuals, but the data protection officer can receive support from individuals within the organization to fulfill their responsibilities. And finally, the data protection officer may require resources such as training and ongoing education around GDPR and other data protection laws. As I said at the beginning, most organizations are probably going to require a data protection officer. For more guidance on the requirements and responsibilities of a data protection officer, see the Article 29 Working Party Guidance on Data Protection Officers.